Hi, this is Sarah Brown with 1851 Franchise, and today I have with me Jess Dance, who is a shareholder in Polsinelli's global franchise and supply network practice. Thank you so much for taking the time to do this, Jess.
Thank you, Sarah.
Awesome. Well, let's just dive straight in. Can you start by telling me how you ended up specializing in franchise law and what drew you to the field?
Yeah, I began my career as an assistant attorney general with the Colorado Attorney General's office, where I litigated a variety of cases on behalf of the state of Colorado and its departments. Great introduction to litigation, but after a few years, I was looking for a new challenge. And it happened that one of the premier franchise litigators in the country, Len McPhee, was looking for an associate to help him out with a variety of franchise related class actions. So my introduction to franchising was multiple related bet the company class actions on behalf of a national franchisor. And from there, the practice grew. Learned a lot, still learning a lot from Len on behalf of a variety of regional, national, international franchisor clients and other brands, and just really grew to love the field. Franchising as a model touches everything. It's a very versatile business model that can be used for about any type of business. So it's very the types of businesses we work with and the types of legal issues those businesses face can be very varied and very interesting, which is tremendously attractive as an attorney.
Awesome. I can tell you're passionate about what you do. Okay. So what do you think is the biggest legal hurdle facing the franchising industry in 2021 and 2022?
I think the biggest hurdle facing franchising right now are the multi-front efforts to hold franchisors liable, or rather to deem franchisors to be the employer or joint employer of franchisees or their employees. And this comes out in a couple different ways that are discrete legal issues, but have a lot of similarities and overlap, both from our franchisees, independent contractors, or are they the franchisors' employees? We're seeing that with judicial and legislative adoption of the ABC test for evaluating these type of independent contractor employee misclassification matters, most notably California's AB5, that really has people on edge. And there's still a lot of wait and see how that's going to impact franchising moving forward. But the IFA has been leading the charge, rightly so, because the risks could be catastrophic for the industry. If franchisees are not independent businesses, but are in fact the franchisor's employees, that changes everything. Not only the direct liability for franchisors, but also the potential vicarious liability for franchisors for the acts of franchisees or their employees. And that's why it dovetails with the ongoing fight and demand for clarity regarding the standard for joint employment. And we've seen a lot of back and forth over the last few years about these various standards, the standards for determining whether two independent businesses are in fact joint employers, as well as the standard for determining employee misclassification matters. And it's not just the simple, the potential liability exposure that faces an ongoing hurdle for franchises and brands, but also the uncertainty. Just in the last few years, we've seen the standards shift dramatically. The Department of Labor issued a final rule in early 2020 clarifying the standard for joint employment under the Fair Labor Standards Act, and included very reassuring language that acting as a franchise did not make it more or less likely that two companies that a franchisor or two independent companies would be joint employers. That was recently rescinded after being challenged in court, and now it's swinging back. Similarly, the NLRB did a final rule a year ago that clarified the standards. Now there's attacks on that as well. So the back and forth really creates a lot of uncertainty for franchise brands about what they can and can't do vis-a-vis their franchisees and their franchisees' employees, and that really inhibits growth, let alone the potential worst case scenarios that could come if AB5 type tests are adopted elsewhere, or its implication is as bad as we fear for franchising.
Got it. Perfect. Okay, so what is the most common mistake that you see franchise brands making from a legal perspective?
Well, fortunately, we have a sophisticated group of clients that either have experienced legal departments or savvy executives who know when to reach out to outside counsel. So I'm fortunate that my clients know when to get in front of some of these issues, but having conducted due diligence on behalf of companies looking to purchase franchise systems and kicking the tires on some other franchise systems, I can definitely tell you there's a lot of times where just presumptions are made that, oh, we as a system can do this without double checking what does the franchise agreement say. And as you know, franchising is a patchwork of sales and relationship laws. Not only do you have the federal FTC rule, but various various states that have their franchise sales disclosure laws as well as their relationship laws. And all the time in conducting due diligence, you'll see franchise systems where they simply presume, oh, the franchise agreement says we can terminate immediately for these grounds. And they don't think, well, the franchisee is in a California or another state that severely kind of restricts what constitutes good cause, or even if there's good cause, you require a mandatory notice and opportunity to cure period. So it's that failure to check the details before taking action that can get people in trouble. And I think that goes to double checking, what does the franchise agreement say? Or has the franchise agreement evolved over years when we as a system are looking to make changes, roll out new programs that may or may not bring additional fees with it. So you got to know what your contract says. You got to know what the governing law says before you take any action.
Good advice. Okay, awesome. So you mentioned earlier how you love that virtually any industry can franchise, but is there anything else that you love about working with franchises?
Yeah, absolutely. One, as you noted, I really do like that franchising is a dynamic and resilient model that can apply to a wide range of businesses. I think that means that we see a lot of different types of, we work with a lot of different types of franchise businesses, and that brings with it a lot of interesting issues. I also love that the people that are involved in franchising, we primarily represent franchisors, but we'll often represent franchisees or franchisee associations as well. And you see franchisors, franchisees alike are very entrepreneurial, passionate about the brand. And it's very refreshing to see people excited about what they're doing. If it's a young system, passionate about their idea and wanting to grow it and start it, or established brands that are looking to grow internationally or into new parts of the country or into new types of offerings because they know that they have something great to offer and they want to find ways to bring it to more people, both to franchisees and to the ultimate customers or end users.
Awesome. Okay, last question for you. So what is one thing you think every prospective franchisee should know before joining a franchise brand?
You got to know what you're getting into. And one of the strengths, one of the primary strengths of franchising is the strength in numbers. You're becoming part of an established brand that has name recognition, and customers off the street expect that the burger that they get at the franchise restaurant in Florida is going to taste and look the same as the franchise at the burger they get at the same outlet in California. And it's that uniformity is critical to franchising, which means if you're getting into it, you need to be prepared to operate. What the customer sees needs to comply with brand standards and system-wide brand standards to ensure a consistent quality of product or services, and that benefits customers, that benefits all franchisees alike. If you as an entrepreneur, a prospect looking at franchise systems, or know that you're going to want to do things your own way, then franchising might not be for you. It's very surprising how many prospects never really take a deep look at the franchise agreement or the FDD before agreeing to make a purchase. And so, as a prospect, you need to know what you're getting into, and that you're going to be operating in compliance, need to be operating in compliance with system-wide brand standards, both for your own benefit and the benefit of the system as a whole.
Awesome. Well, that is all I have for you today, Jess. Thank you so much again for taking the time to do this.
Absolutely. Thank you for your time.